So now that we have spent some time talking about what a constitution is and the different ways in which we can delineate the different characters and characteristics and features of a constitution, I want to draw your attention to the fact that the United Kingdom has what we call an uncodified constitution. It has a constitution that is not all written down in one place, in one singular location. Now, this is important because if there is a constitution that we have that is not all written down in one singular location, that means that by logical extension, it must be the case that the Constitution of the United Kingdom is derived from a variety of different sources. You can find the UK Constitution in a number of different locations. And so if that is the case, we can then start to think about what the sources of the UK Constitution are. Now, what I'm going to do for this video is split this bit up between the parts of this content that requires us to understand the SQE specification and the parts that are more introductory. So I'm going to begin by doing 3 or 4 videos, or maybe 5 videos, that are very brief, very foundational overviews of each of the sources of the UK Constitution. But just bear in mind the fact that the SQE specification will require us to go into these issues in far more detail than we will look at here. So we are still technically on introductory content, although some of this content does pass into the SQE specification. And I will obviously cite when necessary where and what part of the SQE specification we are referring to as and when we get to those points. So as an introduction then, we noted in previous lessons that the UK Constitution is what we call uncodified. And this means, as I've just mentioned, that it is not all written down in one place. We made a delineation between what is known as an uncodified constitution versus what is known as an unwritten constitution, that there is a clear delineation between the two. One is not written down, unwritten. The other is not all written down in a singular place. And so therefore, if this is the case, what are the various different sources of the UK's constitutional framework? What can we refer to as part of the UK's constitution as its various different sources? Well, the formal sources of the UK constitution are as follows. We have statute law as well as secondary legislation. We have the law of the European Union. There's a little asterisk on the side there, and that's obviously because the law of the European Union, as it is made today, does not factor into the UK's domestic system, although the UK retains some aspects of EU law, which we will get to in future lessons. We'll see what parts of the European Union and the place of the European Union in the UK's constitution later on. Prior to Brexit, of course, the law of the European Union formed quite a substantial source of UK law, and so therefore there were aspects of it that formed a clear source of UK's constitutional law. Obviously, this is less so today, but there is still some reference to the European Union when we think about the sources of the UK constitution. Next is the common law. Common law is, of course, the law that is made by judges, and judge-made law as the result of handing down cases and establishing legal precedents. And then when we get to these parts, we're going to start thinking about some elements of the UK Constitution that are not necessarily legally binding parts of the UK Constitution, but are more seen as authoritative guidance towards different aspects of constitutional principles. So constitutional conventions are one such example. Now, they are going to be something that we explore and expand our knowledge on quite extensively, but constitutional conventions are a very interesting part of the UK's framework, given the fact that they are technically not binding legally, they're not applicable in a legal setting, but they are still nevertheless very, very important, and they have quite a significant amount of persuasive authority. And then the last two are firstly works of authority, so clear authoritative works that guide ministers, that guide politicians, MPs, that guide judges in various different directions, and also the royal aspects of the UK's constitution, given the fact that we are, of course, a constitutional monarchy, which is, of course, therefore the royal prerogative as exercised through the executive branch, through the government. So those are the formal sources of the UK's constitution. But what we can also do is delineate these sources and put them on a chart between the legal sources and the non-legal sources. So some sources are legal and some are non-legal. Some are authoritative or persuasive and therefore don't have the force of law behind them, even if they do make comment on various different legal principles and they interact with the law. They are not necessarily legally binding in the sense that a statute is or a case that is handed down. And so when we look at the legal sources, we can see that this includes statute law and secondary legislation, the law of the European Union, again with an asterisk attached to it, the common law, and also the royal prerogative. These are all the legal sources of the UK's constitution. And by contrast, the non-legal sources include constitutional conventions and works of authority. And these are the ones that are non-legal. These are more persuasive sources, and we'll get to those in more detail in future lessons.